Welcome to Employment Law This Week. I'm George Whipple. Our top story, a progress report on labor and employment policy from the U.S. Chamber of Commerce. Marc Freedman is the Executive Director of Labor Law Policy for the Chamber. We caught up with him at EBG's annual Workforce Management Briefing to get an update on how things are shaping up at the DOL, the NLRB, and the EEOC under the new administration.
In the case of the DOL, we've seen some actions from the new Secretary Acosta. They removed some of the interpretations that we didn't favor, and those can be struck by stroke of a pen. So that's impressive to see that happen. It's sort of low-hanging fruit. In the NLRB context, of course, we heard from the chairman this morning, and he described a series of rulings in which he was in the minority and couldn't, push that point across. So we're waiting. There's two nominees that are in process. That will give a 3-2 Republican majority, and once you have that, you can start to reverse some of those decisions and some of the actions of the previous NLRB. Same thing with the EEOC. We're still waiting for the nominees there to be confirmed, who would then create a 3-2 majority in the EEOC. So a lot of what we hope will happen needs those people in place to make it happen.
President Trump nominates a new administrator for the Department of Labor's Wage and Hour Division. Cheryl Stanton has been tapped to fill a position that has been vacant since the president took over in January. Stanton is currently executive director of the South Carolina Department of Employment and Workforce. And during her tenure at the department, she reportedly paid off a debt of nearly $1 billion to the federal government. The Ninth Circuit finds that the Department of Labor is not entitled to deference on tip credit policy. The Court of Appeals ruled on 9 consolidated cases in which employees claimed that a tip credit was improperly applied to times during which they performed non-tipped work. The plaintiffs relied on Wage and Hour Division's Field Operations Handbook, which interprets the FLSA regulation on dual jobs. The guidance stated that employees must be paid full minimum wage for non-tipped work if that work exceeds more than 20% of their hours in a work week. Creating a split with the Eighth Circuit, the court found that the DOL's 80-20 rule is an attempt to create a de facto new regulation and does not deserve deference. And that brings us to our tip of the week. Nosheen Rokaria, Associate General Counsel, Labor and Employment for Visiting Nurse Service of New York, is here with some advice on what to do in light of recent employee arbitration agreement decisions. This includes, most recently, the Gold decision in New York, which found class action waivers to be unenforceable.
New York employers sitting in Manhattan and the Bronx are bound by the Gold decision, and so they should carefully consider the likely impact it will have on litigation strategy of plaintiffs' attorneys. First, plaintiffs' lawyers are unlikely to file FLSA complaints in federal court, where Second Circuit precedent finding class action waivers enforceable is still binding. At the same time, we do expect to see an uptick in state court filings, where plaintiffs' lawyers are likely to seek to nullify class action waivers, making it nearly impossible for employers to then rely on those waivers to defeat class certification. While the Gold decision is current law in Manhattan and the Bronx, the U.S. Supreme Court is actually scheduled to hear oral argument on this very issue on October 2nd. We expect the court's decision to hopefully resolve an outstanding split among the federal courts sometime in early 2018.
Thanks, Nosheen. That's it for Employment Law This Week. Thank you very much for watching, and we'll see you next time.